Oh, I'm back, everyone. Yes, my voice is not 100%, but I have been out for a week with some kind of upper respiratory crap. And this has been sitting around all this time waiting for me to cover it, so I really want to do it even though I'm not 100% recovered yet. So forgive my voice. Hopefully we can get through this, because this kind of follows on to a video I made a few weeks ago when UMG did an earnings call, and we'll hear clips of it. I've got clips. I've had clips of it in the last one too. But they said that AI is not harming the market and in fact will be a net positive. And I predicted that there would probably be lots of amicus briefs and even defendants coming out here talking about it. Well, Anthropic has not let us down. In Concord v. Anthropic, we have a defendant's notice of motion to exclude expert testimony because it conflicts with what they said in this earnings call. So let's get into it. On July 15, 2026 at 10 a.m., defendant Anthropic will move the court for an order granting Anthropic's motion to exclude the expert testimony and opinion of publisher's putative expert, Dr. Michael D. Smith. In a recent earnings call, Universal Music Group, and that's the parent company of a couple of the plaintiffs, told investors that there is
no indication that AI royalty dilution is a material issue for UMG from a revenue perspective. The impact AI will have on our business will be overwhelmingly net positive.
Citing the earnings call and the data they had presented to investors, UMG executives explained that
the case for AI dilution risk has been massively over-extrapolated from a few anecdotes,
and that the risk of dilution from AI slop is
almost entirely mitigated right now
based on
the lack of consumer interest and our ability to put protection into our deals.
It's kind of fun having the recordings, isn't it? Less talking for me. With the way my voice is now, that's a good thing. So publishers offer the contradictory testimony of Michael Smith to support their contention that Anthropic has caused publishers harm and is diluting the market for publishers' works. Smith is no stranger to this court. Publishers relied on him at the preliminary injunction stage to offer the same opinions he offers now. At that stage, the court found that Smith's testimony did not demonstrate how using the works to train Claude is affecting, let alone diminishing, the value of any of the works. Smith failed to show that Claude is harming publishers' negotiating position during the 20 months of discovery since AI has become more central to nearly every aspect of the global economy, as reflected in a surge of empirical research. Yet Smith's opinions that AI is diminishing or diluting the market for publishers' works or otherwise harming publishers remain just as, if not more, conclusory and speculative as when the court first considered them. In other words, he was wrong back then, and things haven't gotten any better. The future may be uncertain. The past is not. Smith's assignment was to identify and measure past harm. He did not do that, nor did he try. Instead, he parroted the litigation-driven assertion that there has been past harm without even considering evidence that led publishers' executives to tell their shareholders the exact opposite. As for future harm, AI is far from the first emerging technology to be subject to economic analysis. If Smith believes that the future impact of Anthropic's conduct is hopelessly indeterminate, then he should not be offering an opinion about it. Right on. Now, a lot of this is redacted, which makes it fun to try and talk around, but we'll do the best we can. Smith also cited statements from Anthropic about the possible future capabilities of AI, but these big picture statements do not demonstrate that Claude has actually generated or ever will generate song lyrics that dilute the market for publishers' lyrics. Smith conceded that he did not perform any empirical analysis about the displacement of songwriters. And he acknowledged that these same documents show that songwriters use AI to help them, while admitting that he did not find a single example of displacement. Not one example of the harm they say AI is causing. Smith claimed that this was not his job, but Smith is providing an expert opinion in this case. Even if not so instructed by counsel Rule 702 makes it his charge to apply a reliable methodology to support his conclusions. He did not. Smith's analysis suffers from an even more astounding problem: his failure to consider publishers' own evidence and statements on the very issues on which he opined, such as that it sees
no indication that AI royalty dilution is a material issue for UMG from a revenue perspective.
UMG's EVP and Chief Digital Officer Michael Nash explained that
misunderstandings have resulted from anecdotal press reports that AI-generated content has somehow overtaken the charts.
But that
nothing could be further from the truth.
In short, UMG reached the exact opposite conclusion as Smith, finding not only that
empirical data demonstrating insignificant and comprehensively mitigated risk,
but that
the impact AI will have on our business will be overwhelmingly net positive.
I know these are short clips. I'm just doing what's quoted here in the paper, but none of these are taken out of context. You've got the links. The links to the original is back in the original video of mine that I'm following up to. There's a link to that down there, and there's a link to the earnings call. The link to these newer comments are down below in this one. So you've got the whole thing. You can listen to the audio of all of it. You can read the transcript. None of this is out of context, I promise you. Another study he heavily relies on shows that over 60,000 AI-generated songs are uploaded daily to a French streaming platform, Deezer. But Smith provided no evidence that any of these uploaded songs contained lyrics generated by Claude, or that a single consumer actually streamed any of those AI-generated songs, let alone that publishers' 499 works in suit received fewer listens as a result. Nor could he. UMG told investors that
85% of AI streams on one representative platform, Deezer, were identified as fraud and then excluded from royalty pool allocation.
In his deposition last week, Smith admitted he had never seen this evidence and that counsel for publishers had not provided it to him. After that, publishers instructed him not to answer any additional questions about it. Yeah, don't answer those hard questions, those questions that make us out to be the liars we are. No, not the difficult stuff. Just answer the questions we want you to answer, the ones that are favorable to us. Now, in contrast, two of Anthropic's experts conducted quantitative analyses to evaluate publishers' claim that they were harmed. One, a regression to assess whether there had been a decline in web traffic to lyrics display websites, and two, an economic analysis to determine whether there had been an impact on publishers' revenue. This is the sort of methodological rigor required of an economic expert opining on harm. That rigor is staggeringly absent here. Smith cannot credibly excuse that failure by citing a lack of data when UMG relied on empirical data in its statements to shareholders. Smith conceded that he did not even ask for the data needed to calculate past licensing harm. See, once you ask for data, you're stuck with it. And if the data goes the other way, you can't opine about your preconceived notions. So yeah, stay away from that terrible data. We don't want any of that terrible data. The data might go against us. Lovely, isn't it? Incredibly, when asked why he did not ask for this data, he claimed it was irrelevant to his analysis. Can you believe that? Oh, to be able to see the thing in parentheses there, to see what he actually said, to see what he actually testified to word by word. Maybe we'll get it unredacted someday, but oh man, that is precisely the problem. Smith viewed his charge as asserting bare conclusions of harm, not applying reliable principles or methodologies to the available facts. Smith employed no methodology to determine such future harm. He acknowledged that he has not done any empirical analysis to assess the theoretical displacement by AI on songwriters or lyrics production. And in his reports, he described how one could calculate future lost licensing revenue, but failed to actually do so. Details. So the court should therefore exclude Smith's opening report, Smith's rebuttal report, Smith's reply report, Smith's supplemental report, and any related testimony, and anything Smith's ever done ever at any time. Just delete him from humanity. Just get him out of there. He's not worth anything. Yeah, I mean, it's really telling, isn't it? So it's like either they're lying to the courts here, or they lied to the stockholders in an earnings report. Either way, that's not good. So it's going to be interesting to see how all of this shakes out. So I wanted to cover that, but there's been one thing since then that I wanted to kind of slip in here because it's not very long. The plaintiffs are trying to slip away on a couple of counts, say, hey, we'll drop those, okay? We promise we'll drop them. At this point, when you're this close to a summary judgment, nuh-uh. You would think people would be like, okay, yeah, drop the charges. But you see, there's a problem with that. If they just drop the charges, they could come back and charge them later, with a different complaint and a different case. So Anthropic filed, after 2.5 years of litigation, publishers did not notify Anthropic that they intend to dismiss their claims for contributory infringement and vicarious infringement until the evening of Sunday, April 19, the day before Anthropic's summary judgment motion was due. 6 days earlier, publishers had insisted they were maintaining their claims when the parties met and conferred. They did not respond when Anthropic followed up by email. Publishers initially refused Anthropic's request for entry of judgment with prejudice. With prejudice means you can't refile. It's not going to come back. Not until the morning of Anthropic's summary judgment filing did publishers agree to dismissal with prejudice. But even then, they refused to agree to entry of judgment on the claims or to stipulate that they would not seek to litigate the same issues in future cases. After defending against these claims for years, Anthropic is entitled to genuine finality, one that precludes publishers from abandoning their claims to avoid an adverse judgment while holding open the possibility of asserting these same meritless issues again in some future case. Because otherwise they could keep doing that. The process is the punishment, remember. They take you to court, drop the charges, take you again, drop the charges, take you again, drop the charges, and they just keep doing that. Dragging you into court, taking up your time, taking up all your money with lawyers' fees, only to drop it and then refile. No, that's not how it's supposed to work. We want finality, Judge! So they do have their summary judgment document. It dropped just this morning as I record this. So I haven't had a chance to read it yet, but I did do a search for it, and yeah, they mentioned Cox. So yeah, Cox is going to matter here. So I'll take a look at that, see if there's anything worth talking about that we haven't talked about already. And also, of course, keep an eye on the other cases, and in particular, how Cox is going to affect them. Because I said that was going to be big. And it's amazing. I've been covering Cox since the beginning, and it started in 2019? I had no idea when I started covering that on the podcast. I thought it was just a story. Yet another story about how the RIAA are being rat bastards. I had no idea that I'd be covering it 6-7 years later, and it would go all the way up to the Supreme Court and become this major precedent. But it didn't. It was such an amazing journey to go through, and thanks to all of those of you who went through that journey with me. And now we've got a new journey that we're on, and I don't know where it's going. Something's probably going to go up to the Supreme Court at some point. Do you want to take this journey with me as we follow it through the cases, through the appeals court, up to the Supreme Court, and see how it goes? If so, then please, comments for the Comic God, shares for the Share Throne, like, subscribe, and the bell. And of course, most of all, donate.pagosity.tv, because man, I got a lot of catching up to do. I've been down for a week. And we've only got another week or so before Heather and I go on vacation, so I definitely have to be over this crap by then. So that means I'm going to be cramming to catch up on everything, not just the things I want to do on YouTube, but the real life stuff as well that brings the real money in and everything. So every little bit that you can do helps, whether it's a one-time donation or regular support, Patreon, Subscribestar, or Discord. Thank you so very much for watching. Until next time, stay strong and be free.